All right, good morning, everybody. This meeting is called to order. Mr. Troman, does anyone sign up for public comment?
Good morning, Commissioners. Les Truman, General Counsel. We have one individual who has registered for public comment. We have Ebony Nicole Mitchell. If you could go ahead and unmute yourself and begin. Okay. Does not appear that Ms. Mitchell has joined the meeting. And so with that, I think we're good to go. Thanks.
Good. Thanks, Les. Thank you very much. Item 3, now turn the meeting over to Commissioner Connett, who preside over agenda items 3 through 8. Mr. Connett.
Fantastic. Thank you, Chairman. And good morning, Ms. Miller. I understand we have no cases to reconsider under agenda item 3. Is that correct?
Correct. No cases.
Very good. We will now consider tax liability cases under agenda item 4. I believe we have no tax cases on dockets 48, 49, or 50. Is that correct?
Correct. No cases.
Very good. On agenda item 5, I understand we have no fair housing cases on dockets 48, 49, and 50. Is that right?
Correct. No cases.
Very good. So agenda item 6, is it correct we have no child labor cases on dockets 48, 49, or 50?
Correct, sir.
We'll now turn to consideration of wage claim cases under agenda item 7. We have no wage claim cases pulled for additional discussion on dockets 48, 49, or 50. Is that correct?
That's correct. None pulled for additional discussion. However, you should have received the wage claim short form dissent list for dockets 48, 49, and 50.
I move that we accept staff recommendations on the remaining wage claim cases on dockets 48, 49, and 50.
I second the motion except for those cases which I am dissenting, as reflected on wage claim short form dissent list for docket 48, 49, and 50.
I concur with the Commissioner's motion, except for the cases in which I am dissenting as reflected in wage claim short form dissent list for dockets 48, 49, and 50.
And the motion passes with the exceptions noted. We move now to agenda item 8 in consideration of unemployment insurance cases on dockets 48, 49, and 50. Please proceed with docket 48 when you're ready.
Yes, sir.
Case number 3605693, Chairman Sparsa.
We should reverse the AT decision. Concerning good cause, the employer provided uncontroverted testimony that they missed the AT hearing due to non-receipt of the AT hearing packet. Since the employer did not attend the AT hearing due to circumstances which were outside the power to control, we should find that the employer established good cause for missing the AT hearing and resubmit the case for merits testimony. As such, we should reverse the AT decision. The employer established good cause for missing the AT hearing. Resubmit.
The AT decision should be affirmed. Regarding the good cause issue, the employer provided no testimony regarding the reason for their failure to attend the prior hearing, and though their petition to reopen states that the hearing notice was not received, the employer presented no testimony regarding their receipt of the notice or their mail handling procedures. Since the notice was mailed to the employer's correct address and the employer provided no evidence to rebut the presumption of receipt, the employer has failed to establish that it had good cause for its failure to appear at AT1. Regarding the job separation issue, the claimant was discharged for failing to follow the employer's standard operating procedures, but provided credible and consistent testimony denying that he made any mistakes or failed to follow any known procedures. Therefore, the claimant was discharged for reasons other than misconduct connected with the work. Affirm the AT, employer failed to establish good cause for AT1, no misconduct, chargeback.
Modify the AT, good cause, resubmit. Because the employer's designated representative did not receive the AT1 hearing packet, the employer demonstrated that it was prevented from attending the AT1 hearing by circumstances beyond its control.
Thank you. We will resubmit the case.
Case number 3675906, Chairman Sparsa.
This case should be, the AT decision should be modified. The case should be examined under medical separation analysis given the final incident. The available record establishes that a portion of the claimant's absences were due to illnesses tied to pregnancy. Consequently, the final incident involved the claimant calling in sick while on a final warning for her attendance. Thus, the claimant should be qualified for benefits and the employer's account should be protected from charge. The AT decision should be modified to no misconduct, no chargeback, MVI.
The decision should be modified. I agree that the claimant was discharged for reasons other than misconduct, as she was discharged after a final incident in which the employer testified that she called in sick. Additionally, though the claimant had some prior absences for personal reasons, her statements to the commission indicated that most of her prior absences were for illnesses that were supported by the ADA documentation. Therefore, the claimant was discharged due to illness and not for misconduct connected with the work. However, as the claimant was discharged due to a medically verifiable illness, the employer's account should be protected from charge. Modify the AT, no misconduct, no chargeback, MVI.
Concur with Chairman Esparza on both vote and rationale.
Thank you. We have a unanimous decision.
Case number 3714792, Commissioner Trevino.
The decision is not supportable. The employer discharged the claimant for failing to meet its performance expectations regarding customer surveys and time spent handling customer phone calls. The claimant worked to the best of her ability and testified that she had 6 different team managers during her employment and had no prior warnings about her job performance until she worked for her final manager. The employer did not provide any evidence that the claimant failed to meet the performance standards prior to working with her last manager. Therefore, the evidence showed that the claimant was not able to meet the performance expectations of her new manager, despite her best efforts, which constitutes an inability to meet this particular manager's expectations and not misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void adequate response.
The AT decision should be modified. The evidence in this case indicates the claimant was able to meet the employer's metrics up until the last several months of her employment. The employer testified that the claimant was warned she was not meeting her monthly goals. Because the claimant was able to perform her duties without being coached for over a year, her failure to meet the employer's expectation in the last months of employment constituted misconduct connected with the work. We should therefore modify the AT decision, misconduct, no chargeback, sever adequate employer response.
Modify the AT, misconduct, no chargeback, sever adequate response. Because there's ample evidence that the claimant was previously able to meet the employer's expectations, but then her performance declined despite several warnings, we should find that the claimant was discharged for work-connected misconduct.
Short form dissent, ma'am.
Yes, sir.
Case number 3731381, Chairman Esparza.
The AT decision should be modified. As to good cause, the employer had good cause for its non-appearance. Regarding the job separation, the employer witness provided firsthand testimony, subject to cross-examination and taken under oath, that the claimant was fired for yelling at her on the claimant's last day of work. The claimant did not provide testimony refuting the employer's witness, since the claimant did not appear at the hearing. Since yelling at a member of management is an action that a reasonable person would know or should know could result in discharge, the claimant's action constituted misconduct connected with the work. We should therefore modify the AT decision. The employer had good cause for its non-appearance misconduct.
The decision should be modified. We previously voted to find that the employer had good cause for its failure to appear at AT1. Regarding the job separation, the employer testified that the claimant was discharged because she had a negative response when she was accused of lying after requesting leave to leave work early due to illness, and because she was insubordinate in asking to speak to the owner after being fired. There is no evidence that the claimant was lying when she stated that she was ill, and the employer's characterization of the claimant's reasonable request to speak to the owner after being discharged as insubordination undermines the credibility of the employer's testimony. Therefore, the employer has failed to establish that the claimant was discharged for misconduct connected with the work. Modify the AT, employer established good cause for AT1, no misconduct.
Modify the AT, good cause, and we should rehear this case for more detailed testimony on the claimant's alleged work mistakes and insubordination, such as the claimant's specific errors and what the claimant yelled to the employer. Moreover, we should also gather documentation on the employer's PTO policy, claimant's work schedule, the claimant's PTO requests, and the claimant's absences.
We have a, yes, sir.
Support Commissioner Connett on a rehear.
Thank you. Majority on, unanimous on good cause, and we will rehear the case.
Thank you very much.
And just one moment, I'd like to just confirm one thing with the previous case. Case number 3714792. Commissioner Conick, could you confirm your adequate response vote, please?
On 3714792,
Yes, sir.
I voted to sever adequate response on that
Thank-
case.
Thank you, sir.
Yep.
And proceeding to the next case.
Case number 3742790, Commissioner Trevino.
The case should be reheard because the record was not fully developed regarding the claimant's final absence that occurred on 2/19/24. The claimant testified that he submitted text messages to his supervisor the night before his scheduled shift and the next morning before he was scheduled to work. The claimant attempted to send copies of the text messages to the commission before the continuation of the hearing and again during the hearing. However, it is not clear why these messages were not received. Since the hearing officer failed to reset the hearing or wait until the text messages were received so that they could be properly admitted into evidence, the case should be reheard to obtain the messages. Rehear.
We should modify the AT decision. The claimant was terminated for being a no-call, no-show on his final day of employment. Although the claimant was repeatedly warned about his attendance infractions, he continued to accrue additional attendance occurrences in violation of the employer's policy. Since the claimant was aware of the employer's attendance rules, his failure to notify the employer about his absence on his final day constituted a mismanagement of his position of employment, amounting to misconduct connected with work. As such, we should modify the AT decision, misconduct, no chargeback, sever adequate employer response.
Modify the AT, misconduct, no chargeback, sever adequate response. Because the weight of the evidence suggests that despite previous verbal warnings, the claimant did not properly call out of work prior to his shift, the claimant should remain disqualified for work-connected misconduct.
Short form dissent, ma'am.
Yes, sir.
Case number 3746866, Commissioner Trevino.
The decision is not fully supportable. I agreed that the claimant established good cause for AT1. Regarding the job separation, the claimant testified she quit her job after the owner of the business directed inappropriate comments towards her while she was performing her job duties, which were offensive and obscene. The claimant was subjected to continuous sexual harassment by the owner, and she discussed her concerns with him several times. Since the claimant had voiced her objections regarding the owner's behavior towards her, and because the owner's actions were egregious enough to constitute workplace harassment, the claimant had good cause connected with the work for quitting. Modify the AT, claimant established good cause for AT1, no voluntary leaving, chargeback.
We should affirm the AT decision. First, I don't contest the good cause issue. Concerning the job separation, although the claimant alleged concerns about her supervisor, she did not make a formal complaint nor attempt to remedy her concerns prior to quitting. Since the claimant quit while continued work was available, her separation was voluntary and without good cause connected with the work. As such, we should affirm the AT decision. The claimant established good cause for missing the AT hearing, voluntary leaving, no chargeback.
So good cause, but additionally, we should rehear to develop the record on the claimant's allegations of inappropriate conduct. The record is underdeveloped as to some of the claimant's allegations regarding inappropriate behavior by the employer. Since these allegations are rather concerning, this case should be reheard for the claimant to develop the record.
Ma'am, I'll agree with Commissioner Conick.
Thank you, sir. We will rehear the case.
Case number 3769025, Chairman Sparsa.
This case should be reheard. The employer provided a written statement from an employee, the only person having a first-hand account of the final incident other than the claimant. As the claimant's testimony and the employee's statement contradicted, we should allow the employer the opportunity to call their employee to testify regarding the final incident. Thus, the case should be reheard to give the employer the opportunity to present their witness with first-hand testimony.
AT decision is correct. After an inconclusive random drug test, the employer placed the claimant on an unpaid suspension pending the retest of the provided sample. The employer told the claimant that it would take up to 3 to 5 days to get the retest results. After being suspended for 8 days, the claimant asked if he could pick up his tools. While the employer alleged that the claimant said that he was quitting when picking up his tools, the employer only provided secondhand testimony, and the claimant denied quitting under oath. Regardless, the employer had already initiated the work separation by suspending the claimant without pay for 8 days. Since the employer did not present any evidence of misconduct, the AT properly concluded that the claimant's separation was not disqualifying. Affirm the AT, no misconduct, chargeback.
I concur with Chairman Esparza. We should rehear the case.
We will rehear the case.
Case number 3776739, Commissioner Trevino.
The decision should be reversed. The claimant provided credible and consistent testimony that she attempted to file her claim certifications timely, but that she was prevented from doing so due to system issues, and that though she attempted many times to call commission representatives to assist in resolving the issues, the calls were either not going through or the line was busy. Since the claimant made good faith effort to file her claim certifications in a timely manner and to resolve the system issues, but were prevented from doing so by circumstances beyond her control, the claimant should not be held ineligible for filing late claim certifications. Reverse the AT, filing eligible.
We should affirm the AT decision. The claimant filed late claim certifications due to alleged technical complications. Nevertheless, the record does not show that the claimant attempted to remedy her concerns or seek alternative methods for filing timely claim certifications. As such, we should affirm the AT decision, filing not eligible from May 5th, 2024 through June 1st, 2024.
Sorry, give me just one moment, please.
Yes, sir.
All right, thank you. Modify the AT, filing not eligible from May 19, 2024 through June 1, 2024. Because there's evidence that the claimant made a diligent attempt to file payment requests for the benefit period of May 5, 2024 through May 18, 2024 on time, we should find the claimant eligible for that time period. But because she stopped attempting to contact TWC after those weeks, the claimant should remain ineligible beginning May 19, 2024 through June 1, 2024.
Ma'am, I'll agree with Commissioner Conick.
Thank you, sir.
I will also amend mine to May 19th. I said May 5th, I believe, in my first.
Yes, sir. Yeah, so we now have a unanimous vote that the claimant was ineligible from May 19th through June 1st. Thank you.
Thank you.
That was the last unemployment insurance case pulled for additional discussion on docket 48. You should have received the UI short form dissent list for docket 48.
I move that we accept staff recommendations for the remaining UI cases on docket 48.
I second the motion except for those cases which I am dissenting, as reflected on UI short form dissent list for docket 48.
I concur with the Commissioner's motion, except for the cases on which I am dissenting, as reflected in UI short form dissent list for docket 48.
And the motion passes with the exceptions noted.
Thank you. Continuing to docket 49.
Case number 3667854, Chairman Esparza.
The AD decision should be modified. The employer testified that its supervisor was only available during a certain period of time and wanted to reschedule the hearing accordingly. The employer's testimony indicates that the supervisor had all the information related to the claimant's separation. Because the employer made a good faith effort to participate in the hearing, it should be held to have a good cause for its non-appearance. We should therefore modify the AT decision. The employer had good cause for its non-appearance. Resubmit.
The AT decision is correct. While the employer stated that they missed the AT1 hearing because their witness was only available for the hearing scheduled between 8 a.m. and 10 a.m. They did not submit any evidence showing that they attempted to reschedule the hearing, and they did not mention this in their petition to reopen. And they did not provide any explanation for why their witness was only available during these specific hours. Therefore, the employer did not establish good cause for failing to appear at AT1. Regarding the job separation, the available evidence showed that the claimant's separation occurred when the employer notified him that he was part of a reduction in force. Therefore, it was proper to conclude that the claimant was discharged for reasons other than misconduct connected with the work. Affirm the AT, employer did not establish good cause for AT1, no misconduct, chargeback.
Modify the AT, good cause, and we should resubmit. We should find good cause because one of the employer's primary witnesses was unavailable during the hearing time.
We will resubmit the case.
Case number 3669869, Commissioner Trevino.
The motion for rehearing should be granted. The claimant's MR offers a statement of firsthand witness, the patient involved in the final incident, who corroborates the claimant's testimony that she did not question the patient about his immigration status. This witness statement directly contradicts the employer's testimony offered at the hearing. The claimant's MR also states that she was only able to obtain the statement from the witness after the hearing and describes how this statement will change the analysis of her work separation, in that it directly disputes the employer's allegations against her. Therefore, the claimant has met its MR requirements, and the rehearing should be granted to allow the claimant to present the statement and testimony from her firsthand witness. Grant the motion for rehearing.
The AT decision should be modified. I don't contest the good cause issue, and I agree that the employer's appeal was timely. As to the job separation, the claimant was fired for asking a patient an inappropriate question. The employer provided a firsthand witness who stated the same and added that the question resulted in the patient feeling uncomfortable. In addition, the employer provided testimony that the claimant had received 3 prior written write-ups. As such, the claimant's action constituted misconduct connected with the work. We should therefore modify the AT decision. The claimant had good cause for a non-appearance, timely employer appeal misconduct.
Excuse me, sir. Can I confirm we're looking at case number 3669869?
3669869.
Yes, sir.
Give me 1 second.
Thank you.
Claimant has not met the criteria, deny MR.
Thank you, sir.
Deny the motion for rehearing. Since the claimant did not provide a compelling reason why the new evidence was not offered earlier, the MR should be denied.
Short form dissent, ma'am.
Yes, sir.
Case number 3674579, Chairman Esparza.
The AT decision should be reversed. The employer testified that the claimant was provided a formal write-up that advised the claimant there could be no more instances of contact avoidance. Nonetheless, the claimant continued to engage in contact avoidance along with not being at her computer. It is reasonable to conclude that avoiding contact and not being at the computer are actions within one's power to control, and the employer was the only party to attend the hearing. Its testimony, which was taken under oath and subject to cross-examination, should be given greater weight. Accordingly, the weight of the credible evidence establishes that the claimant was not working to the best of her ability, which amounted to misconduct connected with work. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision is correct. The employer discharged the claimant for continued performance issues. Despite working to the best of her ability and trying to improve, the claimant was never able to consistently meet the employer's performance expectations during her short period of employment. Since the employer failed to establish that the claimant was ever able to meet their performance standards, the claimant's inability to perform work to the employer's satisfaction does not constitute misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Modify the AT, misconduct, no chargeback, adequate employer response. The claimant should be disqualified for work-connected misconduct because of the deficiencies noted, call avoidance, and excessive idle time. Those items were well within the claimant's control to improve.
Short form dissent, ma'am.
Yes, sir.
Case number 3700377, Commissioner Trevino.
The AT decision is not supportable. The claimant was subjected to egregious behavior by the doctor who ran the medical facility that she worked for 7 years. This behavior was confirmed by several of the claimant's witnesses and was not refuted by any testimony or evidence from the employer. The claimant had complained both to the doctor and to the facility's administrator without any resolution. While the claimant did not file for a formal complaint with the PEO's HR department about the problems that she was experiencing at the facility, there was no evidence that the PEO's HR department could have resolved the problem caused by the doctor who ran the facility. Therefore, the claimant had good cause connected with the work to leave her position due to an unresolved problems that she experienced on the job. Reverse the AT, no voluntary leaving, chargeback, void adequate response.
The AT's decision should be affirmed. The claimant failed to notify the HR department regarding her concerns with the job. Thus, the claimant failed to exhaust all means available to her prior to quitting her job. As such, the claimant's actions constitute a quit without good cause connected with work. Affirm the AT decision, misconduct, no chargeback.
And sir, could you give me please a vote on the adequate response?
Say again.
Adequate response issue? There were 3 issues in the case,
Okay.
separation, chargeback, and adequate response.
Is it, should we sever? Adequate employer response.
Thank you, sir. Have an affirm the AT as your vote.
From the AT decision, misconduct, no chargeback. Yes, adequate employer response
Thank you.
on that.
Concur with Chairman Esparza in his vote and rationale. Thank you.
Thank you.
Short form dissent, ma'am.
Yes, sir.
Case number 3724671, Chairman Esparza.
The AT decision should be modified. After having previously been suspended for policy violations, the claimant was aware that another disciplinary action could result in termination. Nonetheless, the final incident consisted of the claimant sending a text message which included profanity from her personal phone during work hours in violation of the employer's policy. As such, she mismanaged her position of employment, and this mismanagement of employment constitutes misconduct connected with work. Therefore, we should modify the AT decision, misconduct, tax governmental employer.
The AT decision is supportable. The employer discharged the claimant for sending what they considered a disrespectful text message in violation of policy. However, the claimant's message was sent on her personal cell phone to a private group text. She gave credible firsthand testimony that she was allowed to use her personal cell phone while at work due to the nature of the job, and that her text message was just meant to be a funny meme and was not directed toward her supervisor. The employer did not provide direct evidence to refute the claimant's testimony and did not meet their burden of showing that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, taxed governmental employer.
Modify the AT, misconduct, taxed governmental employer, adequate employer response. Because while on a final warning, the claimant sent a text to coworkers that disrupted office operations, the claimant's action amounted to work-connected misconduct.
Yes, sir. And
Adequate.
yes, sir.
Yes,
Thank you.
Short form dissent, ma'am.
Yes, sir.
Case number 3730386, Commissioner Trevino.
While the claimant filed their appeal to the commission 1 day late, this case involves a continued claim related to the claimant working as a marketplace contractor in self-employment. As such, There was no separation from employment, and the continued claim should be voided. Deem the CA appeal timely, set aside the AT decision, void the continued claim.
The claimant's appeal should be dismissed as late because it filed beyond the applicable deadline to be considered timely. There are no good cause exceptions to the timeliness rules. As such, we should dismiss the claimant's CA appeal as late and leave the underlying decision in full force and effect. Misconduct over payment.
Set aside the AT, a timely commission appeal, void the continued claim, no overpayment. The claimant's work as an independent delivery contractor for a marketplace platform was not an employment. Thus, there is no separation and the underlying ruling is void. Because appeal time limits do not apply to a determination that is void from inception, we should deem the commission appeal timely. The claimant's honest reporting of gig work earnings should not trigger a new claim and result in the claimant being disqualified from the receipt of benefits.
Short form dissent.
Yes, sir.
Case number 3749668, Commissioner Trevino.
The decision is not supportable. The employer discharged the claimant for allegedly acting inappropriately during a verbal dispute with his manager. While the employer contends that the claimant violated its zero tolerance policy regarding workplace violence, the employer only provided secondhand testimony of the incident, and the claimant provided credible firsthand testimony that he was verbally accosted by his manager. The claimant denied under oath that he acted inappropriately and had no prior warnings. Therefore, the employer did not meet its burden of showing that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct, bill reimbursing employer.
The AT decision should be affirmed. The employer provided a witness who reviewed video of the claimant acting in an aggressive manner in the workplace. The behavior was so aggressive that it startled a coworker who filed a complaint with the employer. In addition, the employer testified that the display of an aggressive behavior results in termination, since it is a zero tolerance policy employer. As such, the claimant's actions constituted misconduct connected with the work. We should therefore affirm the AT decision, misconduct, reimbursing employer, not billed.
Would like to vote that we rehear this case for the security footage of the final incident, written witness statements, and workplace violence policy, particularly as the employer underwent an investigation of the final incident. We should rehear for this case for the investigation findings to be submitted as evidence.
We have not yet achieved a majority vote.
Ma'am, I'll go ahead and agree with Commissioner Conick over here.
Thank you. We will rehear the case.
Case number 3774381, Chairman Sparsa.
The commission should grant a rehearing in this case. The claimant was terminated for an altercation he had with a customer outside of the employer's store. Parties dispute to what extent the claimant involved himself in the altercation. However, one of the employer's witnesses stated that he reviewed video footage of the incident and felt the claimant was able to remove himself from the situation. Since the video footage of the incident would be dispositive of what occurred during the final incident, we should conduct a rehearing for submission of the employer's video footage of the final incident.
The AT decision is correct. After a disgruntled customer who had already been told to leave the store earlier that day returned and continued to cause disruptions, the claimant and other coworkers told the customer that he needed to leave. The customer became enraged and grabbed a hammer from his vehicle and threatened the store employees. In response, the claimant grabbed a piece of rebar from the store in order to defend himself while trying to get the customer's license plate number for a police report. The customer then took a shovel from his truck and started to swing it at the workers, resulting in the claimant blocking the attack with the rebar. The customer then drove off, and the claimant reported the incident to authorities. Since the claimant only acted to defend himself and coworkers from a violent customer, his actions did not constitute misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
This case should be reheard because the employer indicated that they have video footage showing the claimant physically striking the customer's vehicle. This video should be submitted and the record should be developed as to the claimant's claim that he acted in self-defense.
Thank you. We will rehear the case.
Case number 3791865, Commissioner Trevino.
The AT decision is not supportable. The claimant credibly testified that she did not receive the determination in the mail until after the appeal deadline. Therefore, the claimant's appeal should be deemed timely based on her delayed receipt of the determination and the case resubmitted for merits testimony about the job separation. Reverse the AT, timely claimant appeal, resubmit.
The AT decision should be affirmed. The claimant filed her appeal beyond the applicable deadline to be considered timely, and there are no good cause exceptions to the timeliness rules. As such, the claimant's appeal should be dismissed. We should therefore affirm the AT decision, untimely claimant appeal, misconduct.
Affirm the AT, late appeal, misconduct. We should not deem the claimant's appeal timely because after receiving a copy of the determination in the mail, she still waited 7 days to file an appeal she knew was already late.
Short form dissent, ma'am.
Yes, sir.
Case number 3875866, Commissioner Trevino.
The AT decision is not supportable. The claimant worked full-time for the employer throughout the entirety of his base period. However, due to the employer's cost-cutting policy of paying employees at the beginning of the year for all of their yearly earnings, the claimant only has wage credits in one base period quarter. Though commission precedence holds that wages should be credited to the calendar quarter in which that they are paid to the customer regardless of when they were earned, commission precedents are not binding, and the employer should not be allowed to circumvent liability for unemployment benefits that would otherwise be paid to separated employees simply by paying employees once a year instead of on a monthly or biweekly. Since the evidence established that the claimant had $47,500 in earnings from employment in each quarter of his base period, the claimant should receive the requested wage credit based on the income received from the employer. Reverse the AT, claimant awarded wage credits in the amount of $47,500 from a named employer in each base period quarter. Memo to UIA and OS to investigate whether Amy F. Horton, DDS, PLLC, misreported wages under the claimant's Social Security number, and if not, whether those wages should be included in the claimant's base period.
The AT decision should be affirmed. The amount of base period wages reported by the named employer have been appropriately assigned to the claimant. Accordingly, the claimant is not entitled to additional base period wage credits from the named employer. Should therefore affirm the AT decision. The claimant is not entitled to additional base period wage credits.
Modify the AT, no additional wage credits, memo to investigate whether a different employer intended to report additional wages for this claimant during the base period. Because wages are credited to the calendar quarter of the base period in which they are received by the claimant, regardless of the calendar quarter in which they are earned, we should not add any additional wage credits from the named employer.
And just to clarify, sir, your vote is to affirm the appeal tribunal and send a memo.
Yes.
Thank you, sir. The majority vote is that wage credits would not be granted.
Yes, ma'am, I'll short form dissent.
Thank you,
Thank
and we
you.
will send the memo. That was the last unemployment insurance case pulled for additional discussion on docket 49. You should have received the UI short form dissent list for docket 49.
I move that we accept staff recommendations on the remaining UI cases on docket 49.
And I second the motion except for those cases which I am dissenting as reflected on UI short form dissent list for docket 49.
I concur with the commissioner's motion, except for the cases in which I'm dissenting is reflected in UI short form dissent list for docket 49.
And the motion passes with the exceptions noted.
Thank you. Proceeding to docket 50.
Case number 3338261, Commissioner Trevino.
The decision is not supportable. As to the timeliness issue, the commission previously voted to deem the claimant's appeal timely. Regarding the PUA eligibility issue, while the claimant did not submit her proof of employment to the TWC by the 9/1/21 deadline that she was given, This was because the claimant had already stopped filing claims several months prior and was not aware that she still needed to provide proof of employment to verify the PUA claim that she had already been determined eligible for. The claimant then submitted the required proof of employment to validate her PUA claim with her appeal. Since the claimant was provided the necessary proof of employment to again verify her PUA claim, she should not be held ineligible for benefits she had already been granted. Set aside the AT1 decision, reverse the AT2 decision, PUA eligible beginning 12/27 of 20, no overpayment.
The AT decision should be affirmed and the AT1 should be set aside. The claimant received the PUA notice to provide proof of employment, but the claimant did not provide the requested information at the time because she thought the notice didn't apply to her. As such, the ineligibility and overpayment should remain. We should therefore affirm the AT decision, set aside the AT1 decision, PUA not eligible beginning December 27th, 2020, overpayment.
Set aside AT1, claimant eligible for PUA benefits and no overpayment. Because the claimant was out of status when she received the notice to provide proof of employment, and because she did eventually supply the requested information, we should find the claimant eligible for PUA benefits and reverse the overpayment determination.
Short form dissent.
Yes, sir.
Case number 3679249, Commissioner Trevino.
This case involves an additional claim related to the claimant working as a marketplace contractor in self-employment. As such, there was no separation from employment and the additional claim should be voided. Set aside the AT decision, void the additional claim.
The AT decision should be affirmed. Here, the record establishes that the claimant did not have means of transportation to perform the required job duties. As the claimant could not adequately perform the job duties required of her, she discontinued her work with the employer. As such, the AT decision should be affirmed, voluntary leaving.
Concur with Commissioner Trevino.
Short form dissent.
Yes, sir.
Case number 3725251, Commissioner Trevino.
The AT decision is not supportable. Although the claimant filed a late appeal to the determination in this case, these determinations were not issued until a month after the claimant had already exhausted his benefits and stopped filing any further claims. He had no reason to think that he would still receive correspondence that he would have to reply to from the TWC regarding this claim, and the delay in issuing these determinations amounted to commission misinformation. Therefore, the claimant's appeal should be deemed timely and the case remanded for merits testimony. Reverse the AT, timely claimant appeal, remand.
The AT decision should be affirmed. The claimant filed his appeal beyond the applicable deadline to be considered timely, and there are no good cause exceptions to the timeliness rules. As such, the claim's appeal is late and should be dismissed. Affirm the AT decision, untimely claimant appeal, voluntary leaving, overpayment.
Affirm the AT, late appeal, voluntary leaving, and overpayment. The claimant has not established a timeliness exception for his late appeal because he had reason to expect correspondence from TWC.
Short form dissent, ma'am.
Yes, sir.
Case number 3755329, Chairman Esparza.
We should modify the AT decision. The evidence in this case establishes the job separation was due to the claimant's health. Although the separation due to illness will not constitute misconduct, the employer should be afforded chargeback protection because the separation was the result of the claimant's medically verifiable illness. Modify the AT decision, no misconduct, no chargeback, MVI.
The decision is not supportable. The claimant provided firsthand testimony that she was given the option to either resign or be terminated. Since the employer gave the claimant a choice to either quit or be discharged, the employer initiated the job separation. The employer provided no firsthand testimony or evidence of any misconduct by the claimant. Therefore, the claimant was discharged for reasons other than misconduct. Reverse the AT, no misconduct, chargeback.
Reverse the AT, no misconduct, and chargeback. The claimant should be treated as having been discharged because the weight of the evidence suggests that she resigned after having been given the choice to resign or be discharged. Misconduct should not be found because the employer has not offered sufficient testimony or evidence to prove such.
Misconduct wasn't found, is that correct?
Yes, the majority vote is no misconduct chargeback.
Okay, yeah, short form dissent, please.
Yes, sir.
Case number 37757880, Chairman Esparza.
The AT decision should be reversed. The employer provided testimony that it received the notice in question late. The employer also added that it was having issues receiving its mail in a timely fashion due to being a newly constructed building and mailboxes had been mislabeled. Claimant's contention that he spoke to the manager of the business the employer claimed their mail went to is unpersuasive. There's no guarantee that the manager the claimant spoke to was the only person responsible for handling the mail at the business. Accordingly, the employer was overcome, the employer has overcome the presumption of receipt, and their protest should be considered timely. Reverse the AT decision, timely employer protest, resubmit, please.
The AT decision should be affirmed. The notice of application for benefits was mailed to the employer's correct address of record with the commission on May 15th, 2024, and the employer failed to file a timely protest. The employer's testimony that the notice was misdelivered, causing the employer to receive it late, was inconsistent and therefore not credible. Additionally, the business where the employer alleged the notice was delivered indicated that the claimant that they had not received the notice. Therefore, the employer has failed to provide sufficient evidence to rebut the presumption of receipt, and their protest should be dismissed as late. Affirm the AT late employer protest.
Modify the AT, timely protest, and resubmit. The employer presented credible and persuasive evidence of misdelivery because, first, the assertion that the building mailboxes were mislabeled was never questioned. Second, the claimant's hearsay testimony that one manager didn't know about the mailing issues does not mean that a different manager or owner did not forward the mail to the employer as they asserted. And three, TWC records make it clear that the employer misspoke in their appeal regarding the date of the appeal. As such, the employer's relevant testimony was, quote, clear, direct, and free from inaccuracies and circumstances tending to cast suspicion thereon, and we should deem the protest timely.
Thank you. We will resubmit the case.
Case number 3776623, Chairman Esparza.
The AT decision should be reversed on timeliness. In its appeal to the commission, the employer states that the AT decision was not received in their office until the final day to appeal. As a result, the employer essentially had a one-day appeal window, far shorter than the customary 14-day window. Accordingly, the employer's appeal should be deemed timely. We should therefore reverse the AT decision on timeliness, timely employer appeal, remand.
The AT decision should be affirmed. The wage verification notice was mailed to the employer's correct address of record and was not returned to the commission as undeliverable. The employer failed to file a timely appeal and did not provide a reason for the delay in their appeal to the appeal tribunal. Though the employer addressed their late appeal in the appeal to the commission, they indicated that no notice was received within the appeal period and provided no other reason for the late appeal that would constitute an exception to the timeliness rules. Therefore, the employer's appeal was properly dismissed as late. Affirm the AT late employer appeal, bill the reimbursing employer.
Affirm the AT late appeal, bill the reimbursing employer. We should not deem the employer's appeal timely because after receiving a copy of the determination in the mail on the appeal deadline, they still waited 7 days to file an appeal that they knew was about to be already late.
Short form dissent.
Yes, sir. I have your short form dissent. And that is the last unemployment insurance case pulled for additional discussion on docket 50. You should have received the UI short form dissent list for docket 50.
I move that we accept staff recommendations on the remaining UI cases on docket 50.
I second the motion except for those cases which I am dissenting as reflected on UI short form dissent list for docket 50.
I concur with the commissioner's motion except for the cases which I am dissenting as reflected on UI short form dissent list for docket 50.
The motion passes with the exceptions noted. That concludes our business on agenda items 3 through 8. Chairman Esparza, I hand the meeting back over to you.
All right. Good. Thank you, Commissioner Connett. We shall pause for the shuffle and resume in about 2 minutes.
Thank you, gentlemen.
Thank you, Sherry. Okay, everybody, we are back. Mr. Trobin, you want to come up, public comment? We'll revisit public comment, please.
Good morning again, Commissioners. Les Trubman, General Counsel. So our one registrant is named Ebony Nicole Mitchell. Ms. Mitchell, if you could unmute yourself and begin.
Good morning, Commissioners and esteemed ladies and gentlemen.
We can hear you. Go ahead.
Thank you.
You may want to hang up one phone that you may not be using.
Okay. Yes, sir. Okay, I'm good now.
Perfect.
Thank you for the critical opportunity to present my testimony regarding appeal case number 384-2066-2 on docket 50. The Commission has been provided with an extensive body of evidence, including write-ups and statements, refuting them with witnesses that were never allowed to provide testimony, performance evaluations, pertinent text message communications from August 31st, 2024 through September 5th, 2024, numerous awards and commendations, professional recommendations from colleagues, and a compelling letter of support from the chairman of the Trauma Service Line. Today, December 9, 2025, I, Ebony N. Mitchell, MSN RN BSHS, and with 22 years of dedicated service as a perioperative nurse, come before you to respectfully assert that my termination was unequivocally retaliatory and discriminatory. I humbly request a modification of the Tribune's administrative decision, given the clear instances of discrimination and retaliation I have endured. The employer has demonstratively failed to provide sufficient corroborated evidence to substantiate the claim that I intentionally, voluntarily, or maliciously made a conscious decision to engage in sleep while on duty, therefore violating organizational policy. The allegations lack the specific objective indicators typically associated with active sleep. There was no substantiation that I was motionless with eyes closed, exhibited an unusual relaxed posture, such as being slumped over with my head resting on a desk, or failed to respond to external stimuli like verbal calls, knocking, or gentle physical prompts. Furthermore, no documentation or testimony was presented regarding my breathing patterns being deep, slow, and even, nor was there any mention or proof of snoring or other sleep-related noises. It is crucial to note that I have a medically diagnosed condition of not just asthma, but also sleep apnea, which when I am actually sleeping, I do snore. Throughout my extensive tenure of 8+ years with the organization, I consistently and formally reported a persistent pattern of bullying, defamation of character, hierarchical violence, lateral violence, incivility, harassment, perpetuated by leadership to human resources. This history of reported issues provides a critical context for understanding the retaliatory nature of my termination. At the time of the incident of an asthma attack and dozing off post-medication, which I admit did occur twice, once in February of 2024 and once in August of 2024, I was observing a break with the designated staff lounge and was neither assigned nor had I missed any critical duties pertaining to patient care. I even, after the August 31st date, engaged in a level 1 trauma case post the attack and medicating and had no issues with the care provided. My medical history includes diagnosis of asthma and sleep apnea, which the organization was fully aware of the asthma and has been confirmed by a board-certified pulmonologist, Dr. Clinton Dorr. The employer was fully apprised of my asthma, as evidenced by multiple applications for FMLA, short-term disability, and several annually documented leaves due to asthma, and that was so severe that at times I had to be hospitalized. Moreover, I had formally requested reasonable accommodations related to my asthma in July of 2024. I had also contacted HR upon my return in July of 2024 after my manager made a statement that was not completely true concerning termination if one did not report to duty when contacted to report for code gray during a disaster. She did not appreciate that I contacted HR as she was reprimanded for the incorrect statement made, and she changed my assignment from Team A, which is the write-out team, to the recovery team. This termination stands in stark contrast to the treatment of other employees. I can provide evidence of at least 2 other unmedicated employees on my shift that were observed sleeping by this same leader on separate occasions and were not terminated. Additionally, numerous other departmental employees, nurses, surgical techs, as well as others who were actually sleeping, some with medical issues, some pregnant, and those without any medical history who were tired and have been known to sleep openly for extended periods over several years without facing disciplinary action or termination. It is also pertinent that anesthesia and surgical residents operating under similar institutional policies are routinely provided dedicated sleep rooms and are permitted to sleep during their shifts. The unjust accusations and subsequent termination have inflicted severe and wide-ranging adverse repercussions on both my personal and professional life. My family and I have faced the threat of eviction, which we are in right now, in the apartment that we reside. My storm-damaged home recently emerged from foreclosure proceedings, and I have experienced the repossession of vehicles. Professionally, I'm now prevented from securing employment in any operating room. I have not been able to get a job in an operating room for over a year. I'm also unable to pursue the operating room certification exam, which is a critical requirement for career advancement. These profound and destabilizing events are a direct consequence of this discriminatory and retaliatory action by leaders. I have witnesses to all of the events, and those witnesses were never allowed to testify and provide true statements of what actually occurred with any of my write-ups, including and I don't have any witnesses for this particular incident right here, but I hope that you all will see that my termination was actually discriminatory and retaliatory and allow the opportunity for me to receive back pay. I'm also asking for a 2% increase for the next 20 years and forward pay as well. Thank you so much for allowing me this opportunity.
Thank you. Commissioners, those are the comments we have.
Thank you, Les. We'll get to item 9. Chris Nelson, Chris, come on up here. Item 9 is the 2026 unemployment insurance tax rate. Thank you.
Good morning, Chairman, Commissioners, Mr. Townsend. For the record, Chris Nelson, Chief Financial Officer. The Texas Workforce Commission is scheduled to implement unemployment insurance tax rates for calendar year 2026. The rates have been calculated according to the Texas Unemployment Compensation Act, or TUCA, and the Commission have been briefed on these rates. The Commission is required to set the obligation assessment under the Section 203.105 of the TUCA. The Commission also have the authority to adjust the replenishment tax and the deficit assessment under Section 204.067 of the TUCA. If the Commission would like to set or adjust these rates, they would need to do so with a motion. That concludes my comments, and I'd be happy to answer any questions.
Commissioners, any questions or comments?
None here.
No, thank you.
Employers who have to pay more in taxes have less money to meet their payroll, hire new employees to grow, and this adds to grow their business. We want to keep as much money as we can circulating in the economy. So our goal is to continue to pay benefits and help reduce the likelihood of larger tax rate adjustments in future years and ensure the system remains stable and is prepared for economic fluctuations over the year. So based on this goal, I move that the commission adjust the deficit assessment to 0% and set the obligation assessment at 0.01% for 2026.
I second that motion.
Motion passes. Set the rate.
Yeah, thank you.
On to item 10, discussion considering possible action regarding the submission of fiscal year 2025 Texas Workforce Commission's hiring practices annual report to the governor and the legislative budget board. Kathy.
Good morning. Good morning, Commissioner Khanna. Good morning, Commissioner Esparza, Commissioners Trevino, and Mr. Townsend. Thank you. Sorry. Good morning. I'm Kathy Nguyen, Civil Rights Division. Today's briefing covers the hiring practices annual report as mandated by Texas Labor Code, Chapter 21.504. This law requires state agency to report their hiring demographics to ensure compliance with the state laws. This fiscal year 2025 hiring practices annual report, which is submitted to the Legislative Budget Board and the Office of the Governor, compiles hiring data from the Comptroller, the Board of Law Examiners, and the State Bar of Texas. This concludes my statement. I am happy to answer any questions you may have. Thank you.
Kathy, I get starstruck when I see Randy all the time. Commissioners, do y'all have anything, questions or comments for Kathy?
Yeah. Nothing here. Good job, Kathy.
Thank you.
Ms. Nguyen, just one question of you. Do I understand correctly that this report will be will have a cover letter that explains the statutory reasons for why we're issuing the report?
Yes, this will have a cover letter as soon as it's approved by the commissioners. And last year, Mr. Ed Cerna had a cover letter once it's all commission approved.
Very good. Thank you.
Thank you so much.
I have no questions. Is there a motion?
Chairman, I move that we approve the fiscal year 2025 Texas Workforce Commission's hiring practices annual report for submission to the governor and the Legislative Budget Board as recommended today by staff.
Second.
I also vote yes. Motion passes. Thank you, Kathy. Appreciate it.
Thank you so much.
On to item 11, discussion considering possible action regarding the approval of the internal audit charter.
Morning, Chairman, Commissioners. For the record, Ashley Saugaville, Internal Audit. The Internal Audit Charter is a formal document that defines the internal audit activity's purpose, authority, and responsibility. This document should be reviewed and revised periodically to ensure all information is up to date and accurate. Today, I'm here to present the Internal Audit Charter as discussed with your offices for your consideration and approval.
Very good. Commissioners, any comments or questions?
Nothing here.
None. Thank you.
I have no questions. Is there a motion?
Chairman, I move that we approve the internal audit charter as recommended today by staff.
I second that motion.
I also vote yes. Motion passes. Thanks,
Thank
Ashley.
you.
Motion passed.
Thank you. The next one's me too.
Oh, is it you? Sorry. Hang on where you're at and wait for me then. Item 12, discussion, consideration, and possible action regarding the approval of the internal audit plan.
Again, for the record, Ashley Saugaville, Internal Audit. Today, I'm here to present the fiscal year 2026 audit plan for your consideration and approval. On page 6 and 7 of your materials, you will find the proposed audit projects as briefed with your offices, and I'd be happy to answer any questions you have.
Commissioners, any questions or comments?
Nothing here.
None here. Thank you.
Is there a motion?
Chairman, I move that we approve the fiscal year 2026 internal audit plan as recommended today by staff.
And I second that motion.
I also vote yes. Motion passes.
Thank
Are you
you.
up from 13
That's
too?
all I have
Oh,
today.
okay. I like to be in here. Item 13, discussion, consideration, possible action of the publication for public comment of proposed amendments to 40 Texas Administrative Code, Chapter 803, Skills Development Fund, to add the Texas A&M Engineering Experimental Station as an eligible SDF applicant. Mr. O'Brien.
All right, good morning, Chairman Esparza, Commissioner Trevino, Commissioner Connett, and Mr. Townsend. For the record, I'm Reed O'Brien with the Office of General Counsel. Commissioners, before you today for your consideration for approval are proposed rule amendments to Chapter 803 Skills Development Fund. The proposed rule changes would implement a provision of Senate Bill 856 passed by the 89th Texas Legislature. The bill amended Texas Labor Code Chapter 303 to add the Texas A&M Engineering Experiment Station as a higher education entity eligible for Skills Development Fund support. Staff recommends submitting the proposed rule for publication in the Texas Register for a 30-day public comment period. And staff also requests the ability to make minor, non-substantive changes to the document to comply with the Texas Register and the Office of the Secretary of State's publication requirements. That concludes my comments. I'm available for any questions.
Commissioners, any comments or questions?
None here.
No, thank you.
Mr. Braun, is this program, we're looking at page 8 and 803.3 where it says uses of the fund, item C says technical college training activities shall focus on projects that are not available from a local public community college, except in the technical college's local service area, and shall be encouraged to focus on projects that are statewide. How are we reading this? Does this limit the statewide expand of what are we calling this, T's, to be able to provide statewide training, or are they limited to be outside those service areas?
Chairman, we have a subject matter expert here who can answer that question for you,
Yeah.
Colin Bradley.
He's unboloed.
Not today, no
Good
bolo
deal.
tie
Good for
today.
you.
Good morning, commissioners. For the record, Colin Bradley, Workforce Development Division. Could you repeat the question really quick, sir?
So the question, I want to ensure that I understand it correctly. That item, there's an item, we can definitely talk about this later. I guess it's in the code part of it, but my question is, does this avail the TEES as an eligible SDF applicant? Does that provide them the availability to be to operate statewide and train?
Yes, sir.
Okay.
They will be able to.
I wanted to make sure that was the case too. Okay. Thank you very much.
Excellent.
Colin.
Thank you.
Appreciate both. Is there a motion?
Chairman, I move that we approve the proposed amendments to Chapter 803 Skills Development Fund for publication for public comment as recommended today by staff.
Second.
I also vote yes, motion passes.
All right, thank you.
Item 14, discussion considering the possible action regarding submission of apprenticeship-related instruction cost study for fiscal years. There's Mahalia. Thank you. For fiscal years 2023 to 2024 to the Texas Workforce Investment Council. Mahalia.
Good morning, Chairman Esparza, Commissioner Trevino, Commissioner Connett, and Mr. Townsend. For the record, Mahalia Baldini with the Workforce Development Division. Texas Education Code Chapter 133.006B requires that the commission to prepare and submit a report to the Texas Workforce Investment Council each year. This report covers program year 2023 through 2024 for the apprenticeship training program. The report details apprenticeship funding, enrollment, outcomes, and wages, highlighting the program's impact and key initiatives like pre-apprenticeship pathways and veteran transition grants. Also included are key findings such as increased funding and enrollment, steady contact hour rates, and improvement in our completion rates. Staff are also requesting the ability to make any non-substantive changes to the document prior to submittal to the Texas Workforce Investment Council. This concludes my remarks, and I'm happy to answer any questions that you may have.
Commissioners, any comments or questions?
Just thank you, Mahalia. And just wanted to say this is a very informative and detailed report. And I want to thank Courtney, Desi, and their team for compiling all this information and data. Their hard work is crucial to understanding and supporting the vital role of apprenticeship programs in our state's economy. So thank you.
Thank you for your remarks.
Nothing here. Thank you.
Mahalia, thank you for, we had some questions prior to coming up here, and it was basically just to tighten up kind of understand the language for completion and graduation. If you wouldn't mind, share that with the other commissioners.
Absolutely. So
we
in
can
the
do that.
report, I think one thing to note is that this is a snapshot in time. So this is a report from our apprenticeship programs across the state that provide data to us, and is a snapshot that runs from September 1st of 2023 through August 31st of 2024. In that, in figure 3, specifically within the document, it outlines what we would call graduates versus completers within that program year. For graduation, we are talking there about that 9% would be individuals who actually received a DOL certification within that specific reporting period. It is not going to actually identify individuals that may have received that DOL certification in, say, September or October. So because it is a snapshot in time report, figure 3 is really meant to kind of break down those completion rates, which we are as a state at about 89% completion for all the apprentices in the state of Texas.
Good. That 89% completion for all apprentices. Is that
89%
Okay.
for all apprentices. So we're about 11% attrition rate overall as a
Okay.
state. And 89 is up some from where we were at the last time we submitted this report. So
Awesome.
we're moving in the right direction.
Yeah. Very good. Very good.
No, nothing further. Thank you.
Is there a motion?
Chairman, I move that we approve the fiscal years 2023, 2024 apprenticeship related instruction cost study for submission to the Texas Workforce Investment Council as recommended today by staff.
I second that motion.
I vote yes. Motion passes. Are you here? Yep. Hang on. All right. Item 15, discussion consideration of possible action regarding AEL contracted measures, targets, performance incentive criteria for 25 and 26. Mahalia, please continue.
Good morning again, commissioners. Again, for the record, Mahalia Baldini, Workforce Development Division. This morning, I am also here to present to you the Adult Education and Literacy Program Year 25-26 contracted measures, targets, and performance-based funding criteria as outlined in your notebook materials. The first issue for consideration is our contracted measures. Your notebook materials outline these measures, which include enrollment or participant enrollments, measurable skills gains, as well as exit-based outcomes. Your notebook materials further outline the recommended targets related to each of these measures. In tables 1 and 2 of your materials, this is going to reflect our participant enrollment targets for each set of our AEL grants. That includes targets reflective of the outlined cost PERS in relation to this year's allocation, as well as any carry forward targets associated with any of last year's balances. We also want to point out, as proposed, that total participants served across all grants is 58,955, which exceeds our General Appropriations Act target of 58,649. Moving to table 3, this is going to reflect our measurable skills gain target negotiated with the U.S. Department of Education last summer for this program year. And then table 4 rounds us out with our exit-based measures as outlined in either the state's General Appropriations Act or as negotiated with the Office of Career and Technical and Adult Education, also U.S. Department of Education. The second issue for your consideration has to do with performance-based funding criteria. Texas Labor Code 315.007 requires that the Texas Workforce Commission establish performance-based funding criteria related to high school equivalency enrollment and post-secondary enrollment attainment after exiting the AEL program. The 2 measures are also outlined in your notebook materials. This concludes my remarks, and I'm happy to answer any questions that you may have.
Thank you, Molly. Commissioners, any comments or questions?
None here.
No, thank you.
I have no questions. Is there a motion?
Chairman, I move that we approve the Adult Education and Literacy Program Year 2025, 2026 contracted measures, targets, and performance initiative criteria as recommended today by staff.
Second.
I also vote yes. Motion passes.
Thank you.
Thanks, Mahalia. Item 16, discussion consideration of the year 2026 late refund penalty rate for career schools and colleges.
Good morning, Mr. Chairman, Commissioners, and Mr. Townsend. I'm Michelle Cranes with the Workforce Development Division. Texas Education Code 132.061E requires a career school or college to pay student refunds within a 60-day period. Failure to do so requires the career school or college to pay a penalty. Section 132.061 also requires TWC annually to establish this penalty at a level sufficient to act as a deterrent to the retention of funds. The current penalty rate of 250%, originally set in 1992, continues to provide a deterrent with no late refund penalties assessed in the last 3 fiscal years. Therefore, staff recommends the penalty rate for late refunds to students remain at 250% for calendar year 2026. That concludes my comments, and I'm happy to answer any questions.
Thank you. Any comments or questions?
Nothing here.
No, thank you.
Good. Is there a motion?
Chairman, I move that we approve the career schools and college calendar year 2026 late refund penalty rate as recommended today by staff.
Second.
I also vote yes. Motion passes. Thank you very much. Item 17, discussion considering possible action regarding additional funds to support eligible and qualified applicants to the College Credit for Heroes program. Please.
Good morning, Mr. Chairman and Commissioners, for the record, and Mr. Townsend. For the record, I'm James Golson with the Workforce Development Division. Today, I'm presenting a discussion paper requesting additional funding for the College Credit for Heroes program. Since the College Credit for Heroes program, or CCH, application window opened on August 1st, 2025, TWC has received an unprecedented number of high-quality applications for the program. Existing funding levels will support fewer than half of the applicants who have submitted applications that would otherwise qualify for CCH funding. To support these high-quality applicants, staff recommends an additional $1 million in WIOA statewide funding be added to the total funds available in FY26 to fund additional CCH program applications. That concludes my remarks, and I'd be happy to answer any questions y'all might have.
Commissioners, any questions?
Nothing here.
No, thank you.
Is there a motion?
Chairman, I move that we approve the allocation of an additional $1 million in Workforce Innovation and Opportunity Act statewide funding to be added to fiscal year 2026 College Credit for Heroes program as recommended today by staff.
Second.
I vote yes. Motion passes.
Thank you very much.
Item 19, approve of local workforce development board nominees.
Good morning, Chairman, Commissioners, and Mr. Townsend. For the record, Kara Levy with Workforce Development Division. Today, for your consideration, we have workforce board nominations for the following boards: Cameron County, Deep East Texas, Heart of Texas, Greater Dallas, Lower Rio, North Texas, Northeast Texas, Rural Capital Area, and South Plains. Staff present these nominations for your consideration, and I'm happy to answer any questions you have.
Thank you very much. Commissioners, any comments or questions?
None here.
No, none here. Thank you.
Is there a motion?
Chairman, I move that we approve the local Workforce Development Board member nominees presented today for the following: Workforce Solutions, Cameron County, Deep East Texas, Heart of Texas, Greater Dallas, Lower Rio Grande Valley, North Texas, Northeast Texas, Rural Capital Area, and South Plains.
I second.
I also vote yes. Motion passes. Okay. Sunset review, or what we go to ledger report. The ledger report this morning. Randy's our executive director's report.
Chairman, Commissioners, no report, but I did just want to shout out to all the folks that I know Jennifer's back there in the corner. Looks like she's got a little bit of rest maybe the last couple of days, but the entire team that made the annual conference such a success. I wasn't able to be there in person this year, but did watch some of the sessions virtually. It looked like it was great content shared and lively sessions held at various times, but it looked like everyone was benefiting from the annual conference, a huge success. So I just did want to shout out to all the folks that they make it look easy, but I know there's a lot of hard work that goes into that. So that was really it. Just big thank you.
Thank you for adding that, Randy.
Yeah. I just wanted to echo that, Randy. Thank you, Jennifer, and your team. Always made everything so easy. Patricia Martinez and the workforce development staff, and the MC, Mary York, who did an awesome job. making sure everything was running smoothly. So I just wanted to thank everybody and everybody that's behind the scenes that makes that very special.
Yeah, I'll second that. A lot of very hard work went into the conference. It was a very well done conference. My first, but I've attended other events, and this seemed to run very smoothly. So kudos to the team.
I've also got a lot of good feedback from the boards and from other commissioners. I know the Texas Veterans Commission was there in attendance, and they looks like they get a lot out of those there. So, and also everybody who hosted a workshop, I had a lot of good feedback from folks that were able to get in those and get some good information on that too. So yeah, definitely huge thank you. Looking forward to next year. I'll conclude the executive director's report. Item 24, executive session. The time is now 11:20. Texas Workforce Commission is now going into executive session in room 246, discussing the appointment, employment, and duties of the executive director, internal auditor, executive staff, and other personnel pursuant to Government Code 551074A1. Let's head over to the room. No, we're going to go right into it. Yeah, no break for lunch. Let's go right to it. Thank y'all. Albert, you ready? Hell.
Good answer.
Good answer. All right, I'm calling 3:06. Time is now 3:06. Commission met in executive session beginning at 11:23 a.m. and concluding at 3:04 p.m. No action is being taken. Can I get a motion to adjourn?
Chairman, I move to adjourn.
Chairman, second that motion.
Motion passes and we are adjourned. Thank you, fellow commissioners.
Thank you, sir.
And to everybody who waited up.